afternoon session of the guest lecture. I now request Honorable Justice Ananya Bandyopadhyay ji to continue her lecture on the Criminal Procedure Code or the new criminal law, that is Bharatiya Nagrik Suraksha Sanhita. Thank you.
Post lunch, it must have been a challenge for all of you to come here and to get into the rigmarole of substantive and procedural laws. How many of you want to pursue your career as lawyers, that too as criminal laws? You want to be a criminal practicing lawyer? Criminal law practitioner? You want to be a lawyer? Who else wants to be lawyers? So, but there are different fields. So how many of you want to practice in the criminal field? You want to be criminal law practitioners? Yes. Okay. So now you must have had a preliminary idea of what offences are according to the earlier IPC as well as now the BNS, and what is the importance of evidence as far as the assessment is concerned and the conclusive determination by the court. Now, from the point of view of criminal laws, IPC gives you the definition and the punishment of offences. Evidence Act earlier as well as now the BSA provide for the facts to be placed before the court, burden of proof as to who is going to prove the allegations and how these allegations are refuted, when the burden of proof shifts, what are the presumptions with regard to documents, how the evidence is regarded as far as witnesses are concerned, examination in chief, cross-examination, re-examination, who can be a witness, who can be a proper person to testify, whether the child can be a witness, whether a person of unsound mind can be a witness, laws relating to confession, admission, the assessment, etc., and thereafter how the witness who comes to court is put to test, what are the questions which can be put to the witness by the prosecution or by the plaintiff as well as by the defendant and by the defense lawyer. What are leading questions, whether you can ask leading questions, if so under such circumstances, so on and so forth, are governed by the Bharatiya Shakshya Adhiniyam. Now, earlier it was Criminal Procedure Code, now it is Bharatiya Nagrik Suraksha Samhita. This is absolutely or predominantly a procedural law-based statute. Here you will find the role of the investigating agency, what is an inquiry, what is an investigation, how trial is conducted, depending upon the length of punishment Which are the courts constituted to deal with such offences? What is the role of an executive magistrate? What is the role of a judicial magistrate? Earlier we had metropolitan magistrates, which have now been done away with under the new act. BNSS doesn't provide for metropolitan magistrate. All have become judicial magistrates. What is the role of an additional sessions judge? Role of first track courts, role of the district sessions judge, whether adjournments can be granted while hearing of a matter, how long the police will take to investigate, can there be a further investigation, when a charge sheet is filed, means after the completion of investigation. What is a complaint? A new concept has been introduced, namely zero FIR. What is meant by zero FIR? Earlier under section 125 of the CRPC, maintenance could be claimed either by the wife or by the parents and also by the children who are minor. So what is the jurisdiction for instituting a maintenance case as far as the parents are concerned? The time to be taken by the judge after completion of the argument to pronounce the judgment. So these are basically the procedures that are to be followed. When a person is arrested, that person has to be produced before the court within a particular time period, should be given the opportunity to defend himself or herself. What are the provisions of anticipatory bail matters? So all these are exhaustively covered by the CRPC or now presently the BNSS. Now with the introduction of electronic evidence and digital record, as I told you earlier, there has been substantial change in the procedures mentioned in the BNSS. That is, issuance of summons can be electronically done, evidence can be electronically recorded, the videographed incidents from the device can be seized for marking them as exhibits. There have been specific provisions where the seizure of documents have to be videographed. The signature of the witnesses on the seizure list has to be videographed. It so happens that now do you know what is meant by seizure or what is a seizure list? Do you know? How many of you know that? Suppose an accused is apprehended and a weapon is recovered from that accused. It is said that the police, after thorough search, seizes the weapon. So that weapon is taken from the possession of the accused. That is called seizure. And that the police has seized that weapon from the accused is mentioned in a form that is called seizure list. Now that can be fabricated, that can be manipulated. So this seizure is made in the presence of witnesses who signed on the Caesar list, and they are called the Caesar list witnesses, and when they are called in a court of law to adduce evidence, then they orally cite that on such and such date I was present at the spot where the accused was searched, and from the possession of the accused such and such weapon was recovered. That is his oral evidence. That gets substantiated when the Caesar list is shown by the prosecution. That, do you think this is a Caesar list prepared by the investigating officer or the police at that point of time? If he says yes, then he is asked to identify his signature on the Caesar list. So when he identifies his signature on the Caesar list, it becomes a legal proof to the entire process of Caesar as well as the Caesar list prepared. At times it so happens that this Caesar list witness, when he or she comes before the court, turns around and says, I have signed on the Caesar list, but I did not know what it contained. The police had asked me to sign, so I have signed. Denies the entire. I was not present, I was asked to the police station. It may happen, it may not happen. Nobody knows. So to obliterate that possibility, where the truthfulness of the entire process cannot be properly exercised or ascertained, there has been provision introduced in the BNSS where the process of Caesar and the preparation of Caesar list has to be videographed, specifically in the matters concerning with NDPS Act, means the Narcotic Drugs and Psychotropic Substances Act. There is huge probability of innocent people getting falsely implicated. There are huge possibilities where the persons, they become carriers in the NDPS cases. Suppose a lady sitting on the footpath without food, without basic amenities, is given a 500 rupee note with a bag, asking her to transfer the bag from one place to another. Out of poverty, out of hunger, out of starvation, she falls a prey to it. And when she is caught with the drugs, or for example, it can be ganja, it can be cocaine, it can be charas, all these kind of things, and the laws are so stringent that nobody will believe the actual innocence of that person and might end up languishing in the jail. So these are certain issues, many probabilities are there. So to combat such situations and to establish the truthfulness of situations, the BNSS provides for videography of the entire process of Caesar, the preparation of the Caesar list, etc. Right? Now, just to give you in a nutshell as to why there was a necessity for this BNSS again to be modified. Ensuring speedy justice in conformity with constitutional and democratic aspirations, using of technology and forensic science in the investigation of crime. Now, earlier, the FSL report, the Forensic Science Laboratory report, could be produced through the investigating agency or the investigating officer. to the court. Now, in certain cases, the BNSS has made it mandatory that the person who is preparing the report, who has conducted the FSL examination, he is again an expert in that field. He has to come to the court to adduce evidence with regard to the authenticity of his observation or opinion in the FSL report. Using electronic communication for furnishing and lodging information, service of summons, etc. Specification of timelines for time-bound investigation, trial and pronouncement of judgments. Supplying of copy of FIR to victim and to provide information about the progress of investigation by digital means also. Earlier, victims might not even know as to how far the trial has proceeded, what was the stage of prosecution, so on and so forth. Opportunity of being heard shall be given to the victims before withdrawal of the case by the government in cases where punishment is 7 years or more. In the certain cases where offense of rape, molestation, etc. under section 376 and also section 354 of the IPC, earlier was there, under the direction of the Supreme Court, victim was to be served with a notice. Without the presence of the victim, a prayer for bail petition was not to be heard. If an accused filed a petition for bail, a notice had to be given to the victim also to be present at the time of hearing of the bail petition as in cases of offences against a woman. Primarily also in POCSO cases. You must be knowing what POCSO Act is. These words were not defined in the CRPC. Audio, video, electronic means was not defined. Bail was not defined. Bail bond was not defined. Bond was not defined. And electronic communication was also not defined. Now, these terms are defined in section 2 of the BNSS. Only the process was there. What is an anticipatory bail? Under section 438 of the CRPC you could file. What is a bail? How to file for the provision for bail. That is under section 439 of the CRPC. But the definition as such was not given in CRPC, which has now been provided in the BNSS. Now, the posts of judicial magistrate of third class, metropolitan magistrate and assistant session judges have been deleted from the class of courts. Now, earlier in the metropolitan areas, the judicial magistrate was designated as metropolitan magistrates, which created an issue with regard to section 14 of the SURFACI Act. Now, SURFACI Act is an act of securities, bonds, etc., which fell within the jurisdiction of Debt Recovery Tribunal. And the role of the metropolitan magistrate with regard to section 14 of the SURFACI Act was only administrative in nature, where the magistrate could direct to seize the direct the custody of the confiscated goods. So that created a lot of issues as regards the nomenclature is concerned, because CRPC said it would be judicial magistrate only. So just to remove the anomaly there, or the difference there, the Metropolitan Magistrate, the Court of Metropolitan Magistrate, Assistant Sessions Judge, now the Civil Judge Senior Division, being given the sessions power from any High Court, can deal with the sessions cases at par with the additional district and sessions judges, and also the district and sessions judge of a particular district. Under section 15 of the BNSS, the state government is authorized to appoint any police officer not below the rank of superintendent of police or equivalent as a special executive magistrate in addition to an executive magistrate. And earlier, an executive magistrate would be an officer from the administrative side, absolutely administrative side, can be in the at par with the BDO, block development officers, or the ones who would be the civil services examination, the first rank, the first cadre in the civil services examination, they would be executive magistrate. Now, along with that, they have included the post from the police administration also. A person from the district administration, that is the ones who are coming after giving their civil services examinations, they also include person coming from the police service or the police administration. Now, as far as the power of the court is concerned, what are the changes? Section 23 of the BNSS enhanced the power of magistrate of first class to impose fine from 10,000 to 50,000. The magistrate of second class from 5,000 to 10,000. These two classes of magistrates have been empowered to award community services in the form of punishment. In the earlier session, I have told you what community services are all about, and if you go through the judgments that I have given the decisions of, you will have a comprehensive idea of what community service actually refer to. Community service has been defined as court-ordered work, that this is an explanation to section 23 of the BNSS. It says, or it gives the definition of community service. It says, court-ordered work that benefits the community and which is not entitled to any remuneration. It is in the form of a restorative justice. Section 25 of the BNSS states, in case of concurrent running of sentences in a trial, the maximum period of imprisonment shall not exceed 20 years. Earlier it was shall not exceed 14 years. It was 14 years under section 31 of the CRPC. Now section 25 of BNSS states that it should not exceed 20 years. And now what is meant by concurrent running of sentences? Suppose a person has been convicted under such offences like criminal breach of trust, cheating, forgery, etc. For one particular offence, a period is determined, say for 7 years, say for 6 years, and for 5 years. So it is not that it will be 7 years plus 6 years plus 5 years, which gives rise to 18 years. No, it will run concurrently. So the maximum period the person has to stay in custody would be 7 years. Within this 7 years, for one particular offence, say for forgery if it is 7 years, and then for cheating it can be 2 to 3 years. Now they have changed it. And also for criminal breach of trust, if it is 5 years, or just an example. So 3 of the offence will run concurrently. Directorate of Prosecution in state shall comprise of a Director of Prosecution assisted by the Deputy Director of Prosecution. Now, what is exactly meant by the Directorate of Prosecution of a state? When an offence is committed, like murder, theft, robbery, it is an offence against the state. It's not an offence against a private individual. So the victim gets defended by the state. So state has its own wing called the Directorate of Prosecution. Now what the Directorate of Prosecution does, it appoints the lawyers who are called either assistant public prosecutors or the public prosecutors who defend the victim, in fact who defend the state, because it is considered to be an offence committed against the state. So each and every state at its headquarters has a Directorate of Prosecution. Under the Directorate of Prosecution, there is a list of prosecutors. Now there are 2 channels of inducting these prosecutors. One is at the magistrate level. The lawyers have to sit for an examination to secure the post of additional public prosecutors. That is conducted by the Public Service Commission of each and every state. So they defend the state, or they present the case of the victim, and they are called the prosecution lawyers or the public prosecutors. When it comes to the level of a additional sessions judge, where the sessions matters are dealt with, means 7 years and above, where the offences entail punishment of 7 years and more than that, then the lawyers with a considerable years of practice, it will be very controversial if I use the term, to be appointed by the highest authority of the state, the ones who at that point of time rules the state with their political majority. They only appoint those public prosecutors directly to defend the victim and to appear on behalf of the state. So these are 2 processes in which the public prosecutors are appointed. One at the magistrate level through an examination conducted by the Public Service Commission, and thereafter it's just a selection and an enlistment, you can say, because there is no machinery apart from a recommendation from the district judge or for the Directorate of Prosecution. They are appointed. So now it has been made mandatory that the Directorate of Prosecution in the state shall comprise of a Director of Prosecution assisted by the Deputy Directors of Prosecution, so that they will have a list of empaneled lawyers and then can adequately accommodate them to defend the state as and when required on case basis. The powers and functions. What are the powers and functions? The Director of Prosecution shall be responsible for giving options on filing appeals and monitoring cases punishable with 10 years or more and with life imprisonment or death. The Deputy Director of Prosecution shall examine police report and monitor the cases punishable for 7 to 10 years. The Assistant Director of Prosecution shall monitor cases punishable for less than 7 years. And why is the purpose? What is the purpose for monitoring? So that aptly the cases can be handled in order to defend the state. And where a judgment is pronounced against the state, going through the case records, they will decide as to whether the state will go in for an appeal or not. Suppose in a matter where a person has been acquitted of an offense where the charge was of murder, then the state directorate of prosecution will decide whether the state will go in for an appeal against such acquittal or not. Now, arrest and remand. This is also the first one of the very important steps where once the accused is arrested, then what happens? Section 35(7), subsection 7 of BNSS safeguards people who are aged above 60 years or infirm persons against arrest for offences punishable for less than 3 years. In such cases, no arrest shall be made without the prior permission of the DSP, that is Deputy Superintendent of Police. So this is a new incorporation where a person who is 60 years of age or infirm and has been accused of an offence which is punishable for less than 3 years cannot be directly arrested unless and otherwise the permission of the Deputy Superintendent of Police is taken. Section 37 of the BNSS provides for by ASI with an electronic display board displaying the relevant information, that is name, address, nature of the offence of the arrestee, of the person who has been arrested. Earlier, handcuffing was considered to be unconstitutional. Now with section 43, subsection 3 of BNSS, handcuffing in heinous offences means it can be rape and thereafter murder of the victim. It's one of the heinous possible crime. And in case of habitual offenders, handcuffing has been statutorily permitted. Now, section 40 of the BNSS mandates the arrestee to be produced before the police within 6 hours if the arrest is made by a private person. Section 190 of the BNSS, it mandates that if the accused is not arrested, the police officer shall take security from such person for his appearance before the judicial magistrate. So, according to the police officer, the offence alleged to have been committed by the accused is not so serious that he can be or he should be immediately arrested. But to ensure his appearance before the judicial magistrate, a security is obtained from that concerned person. This provision is in accordance with the direction of Supreme Court in these two cases are very important. You should write it down and thereafter look into it. Siddharth versus State of Uttar Pradesh and another. It is Siddharth versus State of Uttar Pradesh and another, cited in 2022 1 SCC 676. Now this particular case has reiterated the observation of Supreme Court in Satyender Kumar Antil. It's a very famous case. Satyender, S-A-T-E-N-D-E-R, Satyender Kumar Antil, A-N-T-I-L, versus Central Bureau of Investigation and another, in CBI and another. You can write down the citation, 2022 10 SCC 51. Under the earlier act, you should also check up if you are interested. That is section 41 of the CRPC, where prior notice was to be issued to the accused and also to the witnesses. Generally, in offences concerning section 498A of the IPC, 498A of IPC, you must be otherwise also knowing it. There is a tendency of implicating each and every family member in cases of physical and mental cruelty to the wife. So the wife lodges a complaint against the entire matrimonial household. They don't even leave the aunts and uncles of distant relations of the husband staying far away from her matrimonial house, having no connection with the dispute that she is alleging of. So of late, these kind of cases have just mushroomed. So these two decisions you must look into if you are really interested. Now section 187(2) of BNSS states that police custody may be sought for a maximum period of 15 days but in a staggered manner if necessary within 40 to 60 days of detention as the case may be. Earlier provisions you can go through 165, 166 and 167 of CRPC, where it has been stated as to the length of investigation prior to submission of the charge sheet and the number of days a person can be kept in police custody vis-a-vis the judicial custody. Now what is the concept for keeping a person in police custody is only for the sake of investigation. So here, earlier it would be 14 days of remand. I think you people have read it in newspapers. Generally, when a criminal matter is reported, they would say initially, 5 days, thereafter 6 years, or police has wanted for so many number of days of remand, etc., etc. Now, it has been stated either within a gap of 40 days or for 60 days, it can be bifurcated. Say 5 days within 40 days and the remaining so many days within 60 days. But it should not be more than 15 days, that too within a period of 60 days, which can be in the initial period of 40 days and thereafter remaining, or else the entire period of 60 days. Section 51(3) of the BNSS mandates that the registered medical practitioner shall without any delay forward the examination report to the investigating officer. Now it has become incumbent upon the medical practitioner to send the report. Earlier, under the CRPC, when the trial proceeds, the investigating officer would say that I could not collect the medical report from the practitioner. It could have been an injury report, it can be a report, it can be a PM report, that is a post-mortem report after the death of the victim. It can be the medical examination of a victim of rape or sexual molestation, or victim of simple hurt or grievous hurt, etc. So now it has become a bounden responsibility, a liability upon the medical practitioner to submit the report as early as possible to the investigating officer for the sake of investigation and trial. Because for shoddy investigation, the acquittal rate in our country is quite high. The FSL reports are not produced within the normal period because there are very few number of forensic laboratories are there compared to the number of offences that are committed. Report of the viscera, blood reports, the wearing apparels of the victim as well as the accused are sent for forensic examination. Counterfeit coins, counterfeit currencies, they are sent to the concerned CFSL to find out whether they are fake currency notes and all. So the number of laboratories throughout the country, it's not in a very encouraging state. So due to delay, the evidence cannot be proved in a court of law. So this is a step where at least the medical practitioner has to come and deposit the report, not to the whims and frenzy of the investigating officer, because they are not taken to task. They will come and say before the court that I could not collect, the medical officer is no longer there. While conducting trial, it so happened that the PM report or the injury report, which becomes a valuable piece of documentary evidence, which has to be proved by the author of the same in certain cases, apart from exemption under 219 of the CRPC, this is the earlier provision that I am talking of. You need the doctor to come and depose before the court. Either the doctor is changed or has retired or has died due to lapse of time. So nobody comes to court to prove that document, the authenticity of the document. But at least now that will be done. Now, another aspect is the process to compel appearance. Due to the advancement in technology and for the electronic media, how can that be taken advantage of? Now, summons are or can be issued through mail, electronically, so that nobody can say that I have not received the summons. The warrant was not executed. So various technology-oriented changes have been introduced pertaining to summons. As per section 63 of BNSS, summons bearing court, seals and digital signature may be issued through electronic communication. Section 64 of the BNSS mandates maintaining of register as police station with information of persons, address, phone number, email to be summoned. So they have a compilation, they have a register. Through the registered email, the summons are issued, so that nobody can deny that I have not received the notice of, I have not received the summons. As per section 66 of BNSS, summons may be served upon any adult member of the family irrespective of gender. In near future, nobody can come and say that I was not there in the house and the summons was served upon somebody else who was not at all acquainted, so it's not my fault. So this provision has been included, which says it can be served upon any adult member of the family irrespective of the gender. Section 70 of the BNSS, it says service of summons through electronic means shall be considered to be a good service. Good service means it is served and you have received. Because under no circumstances you can deny that you have not received it. So it amounts to good service when the summons is issued electronically. There are certain procedures which relates to attachment and forfeiture of property, which are the powers granted to the magistrate, where the magistrate has the power to attach the property which is identified as proceeds of the crime and dispose of such property even ex parte. Property which is in the nature of, which is perishable in nature. In local language it is called alamat. I don't know what is called here. So an inventory is prepared. Thereafter, in the alamat book, it is recorded the nature, the amount, the quantity, so that at the time of trial it is identified to be true. So these powers are granted to the magistrate. Now, as I told you earlier, under section 125 of the CRPC, the wife, the parents, the minor children can all claim maintenance from the father or the son or the husband. Now here an advantage has been given to the parents of the person from whom maintenance is claimed, that they can claim the maintenance from the court within which the jurisdiction where the parents are residing. Suppose the son resides in Bombay, the parents are residing in Hyderabad. So the parents can institute a case under section 145 of BNSS in the Hyderabad district court or whatever. Now it's very important, the filing of the FIR, that is the first information report. Now let me tell you, there is a distinction between a complaint and FIR. Generally people say, I have filed an FIR, right? That is the language, that I have filed an FIR. FIR means formal investigating report. A complainant goes and files a complaint at the police station. Police registers that complaint through the FIR, that is the first information report, where the complaint is given a number. Suppose such and such police station case number 215 of 2014. It has many sequential numbers, serials, date of the offense, time and date of the information received by the police station, name of the complainant, name of the accused. And through that first information report, the officer in charge of the police station endorses one investigating officer to investigate into the matter. So that is the first information report received by the concerned police station with the details of the alleged offense, with the timing, with the timing when the alleged offense has been committed as mentioned in the complaint. Also the date and time of receiving of that complaint by the police station, the name of the complainant, the name of the accused persons. Thereafter, the investigating officer to whom it has been endorsed to carry on the investigation. So the first information report is issued by the police station and not by the complainant. So the complainant files a complaint, and the FIR is a registered formal document of the police station, right? So now, on receiving any complaint, irrespective of the jurisdiction, the police can register the formal FIR, and that is called zero FIR. Thereafter, it has to be placed before the concerned magistrate within a period of 3 days so that it can be endorsed thereafter and legally proceeded with. Suppose an incident occurs on a moving vehicle. You come to know about it within the jurisdiction of another PS. You were having your luggage, you don't even know at what time your luggage has got stolen. When you realize, you have already surpassed the jurisdiction to another place. So you can also lodge a complaint electronically, which will be recorded, and that is called the zero FIR, irrespective of the jurisdiction. Section 173(1) of BNS provides for filing of zero FIR in light of the observation. Again, write down Satvinder Kaur versus State, that is Government of NCT Delhi, 1998, 8 SCC 728. This provision permits lodging of information through electronic communication, that is EFIR, provided the informant signs the records within 3 days. Section 173(2) of the BNSS introduces the right of the victim to get free of cost a copy of the FIR. The victim can obtain the copy of the FIR so that the victim also comes to know. The victim can be the complainant himself or herself, or somebody else can file the complaint on behalf of the victim, but the victim is entitled to get a copy of the FIR. Under section 173(4) BNSS, it provides for making an application to the magistrate in the event FIR is not registered even after intervention of the superintendent of police. Earlier, it was under 156 clause 3 of the CRPC. If the police refused to register a complaint, a person could have gone straight to the magistrate and said that on this particular date I had gone there, this is the GD entry number, I have been asked by the police to come again, or the police did not take any note of my complaint, I was asked to leave the police station, so on and so forth. So then, taking that complaint into consideration, court would ask the police to register the FIR based on that complaint and initiate investigation. So that provision is now incorporated under section 173(4) of the BNSS. This particular case is also of immense importance. Lalita Kumari versus Government of Uttar Pradesh and others. In this case, where the offence is punishable with 3 years or more but less than 7 years, preliminary inquiry has been asked to be conducted. And in that preliminary inquiry, which is to be concluded within 14 days, if there is no material to further investigate, or it is found to be frivolous complaint, baseless, it won't be proceeded with. And if there are sufficient materials to implicate the accused, the trial will proceed and after conclusion of the proper investigation. So this is a new step in pursuing the decision in this particular case of Supreme Court. Now section 105 of BNSS, as I said, mandates videography of search and seizure, including preparation of seizure lists signed by the witnesses. The provision gives statutory recognition to the directions of Supreme Court in Shafi Muhammad versus State of Himachal Pradesh, 2018 5 SCC 311, which is again reiterated in Paramveer Singh Saini versus Baljit Singh and others, that is 2021 1 SCC 184. There was a case, very famous case, Priyanka Srivastava and another versus State of Uttar Pradesh. That is 2015 6 SCC 287. The decision of Supreme Court in this particular case has been provided in section 175(3) of the BNSS, which provides that in case of cognizable offence, the magistrate may direct investigation on an application accompanied by an affidavit as per direction in this particular case and upon consideration of reports submitted by the police. What is a cognizable and a non-cognizable case? I think you people know it. Cognizable cases are very serious in nature. Section 174 of the BNSS confers power on the magistrate to deal with non-cognizable cases. There are other sections like section 175(1) of BNSS, whereby the officer in the rank of DSP is deputed to conduct investigation, and it states the nature of cases considering the gravity of the offense. Section 176(3) BNSS mandates that in cases involving offences punishable for 7 years or more, forensic experts shall visit the crime scene to collect forensic evidence, as I told you earlier. Section 183(6) subsection 6A BNSS, it states that the statement recorded by magistrate of a witness in offences punishable with 10 years or life or death may be treated as his examination in chief if the witness is temporarily, permanently, mentally, physically disabled. Earlier, these kind of statements were recorded under section 164 of the CRPC. Now it has been mandated under section 183 of BNSS, and this is a specific provision where at the time of recording of the evidence of the witness or the victim before the magistrate, if the same was considered to be in proper physical and mental state, which perhaps gets deteriorated in future, that particular statement recorded before the judicial magistrate at that relevant time, when produced before the court, will be considered to be the examination in chief. Now please let me tell you that a statement recorded under section 164 CRPC, it was not, or still it is not, a substantive piece of evidence. It is corroborative in nature. It's not a substantive piece of evidence. But by virtue of this particular section, it becomes a substantive piece of evidence, because when it is in the form of an examination in chief, it becomes a substantive piece of evidence. As per section 184 of the BNSS, medical examination report shall be forwarded to the investigating officer within 7 days. The investigation is to be informed to the victim through electronic means. The police report as well as the other documents obtained by the police during investigation, the statement of the witnesses recorded by the police, the expert opinion or the report of the medical practitioner or the FSL examiner, all these which comprise the case diary that we say, CD it is called, the case diary. So the entire bunch of the documents present in the case diary will be communicated to the victim through electronic media. Section 349 of the BSS provides voice samples can be demanded from accused without necessitating his arrest. That can be recorded electronically on mobile, or for that matter tape record and send it across. Now, what is the jurisdiction of criminal courts in inquiry and trial? Under section 202 of the BNSS, in case of any offence including cheating by means of electronic communication, place of trial shall be the place where the communication is sent and received. You must be getting I don't know how far you have become aware not to take those calls where they ask you for your bank details, we are giving you credit cards, kind of luring it into in giving your bank details and such and such. So this is a form of a cheating. It's though it's a cyber crime, but again, it's a form of a cheating. So the place where the communication is sent or received. So at the instance of the victim, that becomes the place where the complaint can be instituted. Now under section 208 of the BNSS, it provides if offence is committed outside India, the place of trial shall be where the accused is found or where the offence is registered in India, either of the places. Now the documents which were supplied to the victim can also be supplied to the accused, because the accused also has a right to know the documents, the evidence, either basically the documentary evidence collected against him, because he needs to defend himself also. So he is also entitled to the copy of such documents which can be provided electronically. So section 193(8) of BNS provides for supply of documents to accused through electronic means. As per section 230 BNSS, such supply shall be made within 14 days from the date of production or appearance of the accused. Production means the accused is arrested and produced before the court of law, whereby he can file a petition for obtaining bail if he is not released from the custody of the police, and the police wants for further remand for the sake of investigation. Section 232 BNSS mandates commitment to be made within 90 days from the date on which magistrate takes cognizance. Now, what is meant by commitment? The magistrate has the limitation to try certain offences which is punishable till 3 to 7 years. Beyond that, it becomes the jurisdiction of a sessions court to try the offences. Now, if a record comes before the magistrate and the magistrate finds that it has to be tried by the court of session, magistrate records that and sends it to the court of the district judge along with the copies, and an entire set of copies are given to the accused. So when it is done so, it is called commitment. The magistrate cannot keep the record which is beyond his jurisdiction to try after expiry of 90 days. It has to transmit the case records to the court of session which has the jurisdiction to try the offence. Section 223 of the BNSS states at the time of taking cognizance, opportunity of hearing is to be granted to the accused. This is a very dicey provision that has been introduced by the BNSS. Initially, the magistrate could take cognizance recording the reasons. But here now, under the BNSS, the magistrate has to hear the accused before taking cognizance. Without hearing the accused, the magistrate cannot take cognizance of the offence alleged war. Earlier, there was no such provision. This is a new provision. It will increase the bulk of magisterial work, and once you, of course it's not mandatory, to presume or to determine the case, but it has been a criteria that the magistrate has to follow. Right? Section 175(4) of the BNSS provides that no cognizance shall be taken against a public servant where offence is committed in discharge of his official duty until magistrate receives views of the public servant accused of crime and a report from his superior. So this is a safeguard given to the public servant unless and until there is an observation from the superior that process should be initiated against a public servant. Cognizance cannot be taken provided the offence alleged of is during the course of the duty of the public servant. And in this case, if the prior sanction of the government is necessary, then that has to be obtained and the government shall give its decision as to whether, give its decision in this case, sanction will be accorded to proceed against a public servant. That too, it has to be done within a period of 120 days. Now in Sessions case, there is a timeline to file discharge petition. Discharge petition in the sense, the accused files a petition saying that I am innocent. These are the facts that one should consider, and upon hearing both the sides, if the court is convinced that to proceed with the trial will be futile, in any case it will end up in acquittal of the accused and there is no material sufficient enough to implicate the accused, will allow the petition for discharge, that too within 60 days from the date of commitment. This is in Sessions case. Within 60 days of commitment, the charge has to be framed. It can be either through physical means or through video, audio-video means. Earlier, there would be dates after dates for framing of charge, because accused will not turn up unless and until the accused is present before the court. The charges are read out to the accused, and the accused verbally in his physical presence tells the court either I am guilty, or that is plea bargaining, one pleads guilty. Plea bargaining is somewhat different, but one pleads guilty, and generally in majority it happens that the accused says I am not guilty, and that is recorded in the charge, in the form where framing of charge is done. Charges in different heads are being recorded. It is read out to the accused individually. They will say, I am not guilty and I will proceed with the trial. So that is also recorded in the order sheet. And then the prosecution witnesses are called for to adduce evidence. It would so happen that the accused who are already on bail will not turn up on the dates the court recorded for framing of charges. So in their physical absence, the court cannot frame the charges. So days after days, date after date would be there. The court is not required. Through audio-visual means, the charges can be read out and then can say whether they are guilty or not, whether they are willing to proceed with the trial or not. So this process has somehow become simplified. This method is also available for examination of the witness, the victim, through audio-video means as per section 254 of the BNSS. The prosecution and the defense, lawyers also need not be present before the court. As you can see, nowadays the live streaming, you are accessible to the courtroom. You can find, the lawyers addressing the court through audio-video means, sitting at their chamber or at their house also. So they need not appear before the court. So the witness also in the same manner, they need not appear before the court. The victim may not appear before the court, but the entire examination in the entire process of recording trial can be conducted without their physical presence in the court through audio-video means. Now again it says certain general provisions. Section 346 of the BNSS, it says not more than 2 adjournments shall be granted to a party when the circumstances are beyond his control and upon consideration of objection of the other parties. And I have already mentioned section 356, where there can be a trial in absentia. There can be a joint trial of the persons who were arrested and the persons who were the absconders. Section 356(1) of BNSS provides trial may proceed against a proclaimed offender in absentia and the judgment may be pronounced. This provision has been incorporated in view of the directions in Hussain and another versus Union of India. This is again a very famous case, 2019 5 SCC 702. Now the concept of plea bargaining. Section 290 of BNSS provides that application for plea bargaining may be filed by accused within 30 days of framing of charge, and within 60 days a mutually satisfactory disposition is to be worked out between the public prosecutor, the complainant and the accused. Again, this is restricted to certain offences. There cannot be a plea bargaining in case of a murder. Maybe in the petty offences, how to balance the gravity of the offence, and plea bargaining can be in the form of a compensation. And also nowadays, with the introduction of the concept of community service, that will be adequately worked out. As per section 293 of BNSS, the court may impose a sentence equal to 1/4 of the minimum sentence prescribed in law for the first time offender with no criminal antecedent. This latitude was not available to the court under section 265E of the CRPC. So this was not there earlier, that if you are a first time offender, considering the gravity of the matter, 1/4 of the minimum sentence can be awarded. Now, certain provisions with regard to bail, as to when a petition for obtaining bail can be granted. If there is a considerable delay in the trial, section 479 BNSS provides bail may be granted for first time offender with no antecedents who have undergone detention for 1/3 of maximum period of imprisonment prescribed in law. In other cases, detention undergone should be half of the maximum period. Let me give you an example. In NDPS cases, bail is not obtained easily. Now the trial is in process. Now it is seen that if the maximum punishment would be, say, 10 years, the trial has not culminated even after 6 or 7 years. So there has been inordinate delay in the process of trial. So if that person seeks for bail, the bail will be automatically granted. So this is generally in NDPS cases, this happens, not always, but if there is sufficient period of delay in conducting the trial doesn't get over, then the accused is granted bail very leniently. Now, bail shall not be denied in certain cases. The proviso to section 480 BNSS lays down in case of non-bailable offence, bail shall not be denied to an accused on the ground that he may be required to be identified by witnesses during investigation, or police custody will be required beyond 15 days, provided he is otherwise entitled to bail and gives an undertaking that he shall comply with the direction as may be given by the court. Have you heard of the term TI parade? What it is? Test identification parade. Generally in robbery, dacoity, these kind of cases, the accused in the correctional home is placed with a number of similar looking people so that the complainant comes to the court in presence of a judicial magistrate. After complying with the necessary provisions, can identify that on the relevant date, at the specified spot of alleged offence, this particular person was involved in the commission of the offence or crime. So that is the test identification parade. So after 15 days, if the investigating officer has not complied with these provisions, in the sense the TI parade was not conducted, whatever relevant information was required to be taken from that accused was not done, and the entire process is prolonged, he cannot be kept in the custody, has to be released on bail upon granting bail bond and proper surety. As per section 360 of the BNSS, no prosecution shall be withdrawn without giving opportunity of hearing to the victim. The prosecution, as I have mentioned to you, who represents the prosecution, who are there on the part of the prosecution, the state cannot whimsically say that I am going to withdraw the case. The court has to hear the victim because the state represents the victim and the society at large. Therefore, the state in its own accord cannot ask the court that I will withdraw or the state will withdraw a particular case. Now there is a witness protection scheme formulated which has been mentioned. This is for the first time under section 398 of the BNSS. This also translated the directions of Supreme Court in Mahinder Chawla versus Union of India. In this particular case, Mahinder Chawla versus Union of India, that is 2019 14 SCC 615, this entire scheme of witness protection has been mentioned, which has now been replicated in section 398 of the BNSS. Now, BNSS also stipulated the timeline for delivery of judgment. In the summons case, under section 258 of BNSS, the judgment in a summons case shall be delivered within 30 days, which can extend till 45 days. And in other criminal trials, under section 392(1) BNSS, the judgment in every criminal trial to be produced not later than 45 days after the termination of trial. Means the trial is concluded, both the parties, both the lawyers, either on the side of the prosecution as well as on the side of the defense, completes the argument, and the judge thereafter has to pronounce the judgment within 45 days. And the judgment, after getting pronounced in open court, has to be uploaded in the website within 7 days. At the time of pronouncement of the judgment earlier, the accused had to be present before the court. Now the accused can appear online through video, audio-video means also. Now after there is a death penalty, generally a mercy petition is filed. Under section 472 of the BNSS, the mercy petition is to be filed before the governor within 30 days. If it is upheld, and 60 days, within 60 days before the President of India, that means after it has been finally decided by the Supreme Court. And as per section 530 of the BNSS, the entire process of trial can be held in electronic mode. So these are the comprehensive changes that have been brought in the BNSS in comparison to the earlier Criminal Procedure Code. I have taken a lot of your time because I thought that I cannot miss any of the provisions. So thank you very much for your precious time, and the students sacrificing their Saturday evening